Okay, today we begin our discussion of civil procedure. Civil procedure refers to the rules governing how lawsuits move throughout the court system. So this includes things like filing lawsuits, serving parties, discovery process, venues, jurisdictions, evidentiary rule sets, and how the courts determine what information can and cannot be admitted. And this lesson ties directly into many concepts from last week that we went over regarding personal jurisdiction, venues, forum shopping, diversity jurisdiction, and forum selection clauses. And today we're going to be moving deeper into procedural law itself. The three cases we're going to be covering today all deal with major procedural questions. Hanna v. Plumer, when do federal procedural rules override state procedural rules? Erie Vioxx, what communications are protected by attorney-client privilege? And Kane v. George, what evidence counts as hearsay and what evidence is relevant? When many people first hear the phrase civil procedure, they assume that it's just technical jargon or maybe some boring paperwork. But civil procedure is actually incredibly powerful, because these procedural rules really determine who can sue who, where they can sue, what evidence gets admitted, what information will stay hidden, and whether the case can even survive long enough to reach trial. So sometimes procedural rules matter just as much as substantive law. A plaintiff might have a strong case factually, but if they file it in the wrong court or fail to properly serve process, or if they lose an evidentiary dispute, then the case itself could collapse entirely. So today's lesson is more so demonstrating exactly how these procedural rules can shape the outcomes in different cases. So today's lesson builds directly on the material from last week. Before discussing the case of Hanna, we need to revisit several concepts. Personal jurisdiction refers to the court's authority over a defendant. Venue refers to the proper geographical location for litigation. Diversity jurisdiction allows federal courts to hear disputes between citizens of different states. Removal refers to transferring a case from a state court into a federal court. Forum nonconvenience allows a case to be transferred primarily for convenience. And all of these concepts are interconnected because they determine, like I said before, where the litigation happens, what laws are applied, and what procedural rules can govern the dispute. And this is why parties will often try to engage in that forum shopping, which we discussed last week. The case of Hanna v. Plumer asks what procedural rules apply once a case properly enters federal court. So it sounds simple at first, but this case becomes one of the more foundational civil procedure decisions in American law. So the underlying facts in this case involve a car accident taking place in South Carolina. The plaintiff was from Ohio, the defendant was from Massachusetts. But because the parties were citizens of different states, the plaintiff filed in federal court under diversity jurisdiction. However, the defendant ended up dying, and this created a procedural complication. The plaintiff served the defendant's wife with the summons and the complaint pursuant to Federal Rule of Civil Procedure 4. But Massachusetts law required direct service on the executor of the estate. The executor argued because state law controlled, service was improper and the lawsuit should be dismissed. The lower courts ended up agreeing. This was appealed, and then the Supreme Court had to decide, when state procedural law conflicts with federal procedural law, which rules controls in federal court. This becomes one of the most important Erie Doctrine cases ever decided. So to better understand the case of Hanna, I think it's important that we revisit Erie. Erie Railroad Co. v. Tompkins held that federal courts cannot create their own general common law. Federal courts exercising diversity jurisdiction must apply state substantive law. Now, why is this? Well, this is because otherwise parties would forum shop. If federal courts created completely different legal outcomes than the state courts, then parties would strategically file in whichever court favored them the most, as we went over last week. But Erie mainly addressed substantive law. Hanna asks, what about the procedural rules? Now, if we look back to Guarantee Trust Co. v. York, the Supreme Court stated that the federal courts should apply state rules when ignoring the state rule would substantially affect the outcome. And this became known as the outcome determinative test, because Chief Justice Warren and Hanna explained something important, that almost every procedural rule affects outcomes in some way. So if we took the case of York literally, then federal procedural rules would barely exist. So Hanna therefore narrows York. So now we get to the holding of Hanna. The Supreme Court reversed the lower court's decision. Chief Justice Warren explained that Congress has constitutional authority to create procedural rules for federal courts. The authority comes from Article 3, the Necessary and Proper Clause, and the Rules Enabling Act. As long as the federal rules do not alter substantive rights, then the federal rule controls. Therefore, Federal 4D1 governed service of process in federal courts. The Massachusetts rule did not apply. In this case, heavily relies on the Rules of Enabling Act. The Rules Enabling Act gave the Supreme Court authority to create rules governing federal court procedure. But there is an important limitation. Federal procedure rules cannot abridge, enlarge, or modify substantive rights. In other words, federal procedural rules are allowed so long as they are truly procedural. Now, a key rule to remember from Hanna is that if there's a valid federal procedural rule that directly addresses the issue, then the federal courts have to apply federal rule. So it's only when there's no federal rule, or the rules are ambiguous, will the Erie considerations become more important. So this case therefore preserves the authority and uniformity of the federal court system. And you can also ask yourselves, what would happen if every federal court had to allow every individual state procedural rule? Just think about these things like, would federal litigation become more chaotic as a result of this? Would the federal courts lose consistency? And I think these is just like some of the tensions that are underlying Hanna, balancing the state's authority with the need for a functioning federal judicial system. And now we shift from procedural rules into discovery and evidence. Discovery is designed to promote fairness by requiring both sides to exchange relevant information before trial. But not every communication has to be disclosed. Some conversations are protected because the legal system views confidentiality as essential. And that brings us to one of the more important evidentiary protections in American law, that being attorney-client privilege. The privilege exists so clients can speak honestly and openly with their attorneys and seek legal advice without fear of those communications that are going to be exposed in court later on. But the case we're going to be looking at raises a difficult modern question. In large corporations, thousands of emails and internal documents might involve attorneys in some way, shape, or form. So would copying a lawyer on a communication, such as like an email, automatically make the email privileged? Or could corporations abuse the privilege by routing ordinary business discussions through legal departments to shield evidence from discovery? And so in this case, the court has to balance two different competing concerns, protecting legitimate confidential legal advice, while also preventing corporations from using the attorney-client privilege as a blanket shield to hide their information. Getting into the case of Vioxx, Vioxx was a prescription drug manufactured by Merck. It was intended to treat arthritis and pain. However, later studies testing the drug linked it to increased risks of heart attack and strokes. After the drug was removed from the market, thousands of lawsuits were filed against Merck. Many of the plaintiffs alleged there was a failure to warn about the dangers of the drug, fraud, product liability, and negligence. And so, as you can imagine, the litigation became massive. Now, during the discovery, the plaintiffs requested internal company documents. Merck withheld approximately 30,000 documents claiming the attorney-client privilege. Not as many documents as the Epstein files, but quite a lot. And the court essentially had to order the documents to be submitted for a in-camera review, and this essentially means that the judge privately reviewed the documents outside of the presence of a jury. The court also appointed Professor Paul Rice as a special master to analyze these documents. So the attorney-client privilege exists to encourage honest communication between clients and lawyers. And like I mentioned before, the privilege generally protects confidential communications between attorneys and their clients. This is made primarily for legal advice. But without that privilege, the clients might hide information from their lawyers, and so this would overall undermine the legal system. So then we get into overall corporations and their privilege. So corporations, unlike people, they don't have a Fifth Amendment right against self-incrimination, but they still do receive attorney-client privilege protections. Now, corporations still need legal advice, and the Supreme Court in Upjohn recognized that corporate employees must be able to openly communicate with their legal counsel. So the main question here is, were the communications that Merck sent to their attorneys primarily for legal advice, or were these just ordinary business communications? And so that's where you really have to distinguish the primary purpose here. And Professor Rice explained that if communications are primarily made for legal advice, then the privilege would apply. But if the communications are primarily business-related, then the privilege would not apply. And this became difficult with Merck because it routed so many internal emails through the attorneys regardless of whether the communications were truly legal in nature. So one of the major problems Merck had was they just sent so many emails simultaneously to attorneys, just their business personnel, marketing departments, and other non-legal employees. So Professor Rice had to conclude that many of these emails were just collaborative business communications, and therefore the primary purpose was not seeking legal advice from counsel. So as a result, the attorney-client privilege didn't apply here. So the primary takeaway from Vioxx is that you just can't simply copy an attorney into every email you send out and suddenly make all corporate communications privileged by that nature alone. The court has to focus on the primary purpose of the communication, the participants within the email, and whether the email itself was actually seeking legal advice, that being the primary objective. You're asking for legal advice. This case has become extremely influential in corporate litigation and electronic discovery due to this. And you could say this is even more relevant today just based on how many modern corporations communicate constantly through things like email, Teams, text messages, cloud systems, even using AI messages, etc. So, the courts are increasingly facing these difficult questions about how we can handle things like confidentiality, privilege, and of course the electronic discovery. So as our communication technology evolves, obviously the law has to evolve with it. Okay, so we're on our final case today of Kane v. George, and this is more so about hearsay and relevance, moving into more of evidence law, specifically just admissibility, relevance, and hearsay. So this case is much shorter than Vioxx, but it definitely teaches an important evidentiary principle. Okay, so getting into the case facts. In this case, a child tragically passed away from carbon monoxide poisoning while they were staying at a hotel. The parents argued that the heater was defective, that it was improperly installed, and that it was improperly vented. But the motel owner was arguing that the parents must have accidentally caused a chair fire, which then produced the carbon monoxide, which then in turn killed the infant. So the motel owner wanted to testify that previous guests stayed in that same room without any complaints whatsoever. And this brings us to our issue of hearsay. Was the motel owner's testimony hearsay? And that is essentially what the plaintiffs were arguing, that the motel owner's testimony was hearsay. And why is this? Well, that's because the owner was indirectly discussing what prior guests had experienced. And the plaintiffs in this case were arguing that the guests themselves should testify. So the court here had to determine, was this testimony actually hearsay? So of course we need to define what hearsay is. Now hearsay generally refers to an out-of-court statement offered to prove the truth of the matter asserted. Now the reason hearsay is often excluded is because the speaker cannot be cross-examined, because credibility cannot be tested, and because the information might be unreliable. But not every statement involving another person becomes hearsay. And this is where we get into the Federal Rules of Evidence, or FRE 401 and 402. So FRE 401 is evidence is relevant if it tends to make a fact more probable or less probable. So applying FRE 401 to this case, the testimony would have mattered because if many of the prior guests had stayed safely in the room, that fact arguably made it less likely that the heater itself had caused the poisoning to kill the infant. So therefore that evidence was relevant. Now if we look at FRE 402, this is stating that relevant evidence is generally admissible, unless another rule excludes it. So because the testimony was relevant and was not hearsay, it was admissible. So to wrap up Kane v. George, this case is important because it reminds us that courts draw a major distinction between whether evidence is admissible and whether it's actually convincing. Just because testimony comes into a court doesn't automatically mean that the jury has to believe it. The case also helps us clarify hearsay doctrine, as I mentioned earlier, by showing us that not every out-of-court statement automatically becomes inadmissible hearsay. So courts look very carefully at what statement is being introduced and whether it's actually being offered for the truth of the matter asserted. And at the same time, this case definitely reinforces the importance of witness credibility. A witness may legally testify, but the jury still has to evaluate reliability, consistency, and whether the testimony actually makes sense in the context of the case. So in other words, credibility becomes a factual question for the jury rather than just a legal question for the judge. So overall, Kane v. George is really about the balance between access to evidence and the jury's role in deciding what evidence actually deserves weight. So today's cases demonstrate how procedural law can shape litigation. Hanna teaches us that federal procedural rules maintain consistency in federal courts. Vioxx teaches us that attorney-client privilege has limits, especially in corporate communications. Kane v. George teaches us that evidence law depends heavily on relevance and reliability, and together all of these cases show us that procedure is not just technical. So procedural rules often determine what evidence the juries will see, what the courts will hear, where the lawsuits are filed, and ultimately who will win or who will lose.